5 seconds to go. Start. Thus, according to him, the entire licensing scheme must take into account the weight classification to ensure clarity. The earlier unamended Act set the weight limit at 6,000 kg, which was further raised to 7,500 kg by way of the 1994 amendment. Therefore, the legislature intended to demarcate vehicles depending on the weight and not the description of vehicle. It was further argued that in the event of a conflict between the Act and the rules, schedules, or forms, the provisions of the Act will take precedence. Reliance was placed on the decision of this court in Afali Pharmaceuticals Limited versus State of Maharashtra. Ms. Anita Senoy, learned senior counsel, additionally argued that on the strength of Mukund Devgan 2017, the auto drivers were permitted to operate taxis and motor cabs while holding a driving license for LMV for the past 6 years. Reconsideration of the same is not merely an issue of insurance coverage, rather, it would directly impact the livelihood of those driving transport vehicles with an LMV license. Their rights under Article 19(1)(g) of the Constitution of India should also be factored in for the interpretative exercise. From the above submissions, the following specific issues fall for our consideration. Whether a driver holding an LMV license for vehicles with a gross vehicle weight of less than 7,500 kgs as per section 10(2)(d), which specifies light motor vehicle, can operate a transport vehicle without obtaining specific authorization under section 10(2)(e) of the MV Act specifically for the transport vehicle class. Whether the second part of section 3(1), which emphasizes the necessity of a driving license for a transport vehicle, overrides the definition of LMV in section 221 of MV Act. Is the definition of LMV contained in section 221 of MV Act unrelated to the licensing framework under the MV Act and the MV rules? Whether the additional eligibility criteria prescribed in the MV Act and MV rules for transport vehicles would apply to those who are desirous of driving vehicles weighing below 7,500 kgs and have obtained a license for LMV class under section 10(2)(d) of the MV Act. What is the effect of the amendment made by virtue of Act 54 of 1994 with effect from 14th November 1994, which substituted 4 classes under clauses E to H in section 10 with a single class of transport vehicle in section 10(2)(e)? Whether the decision in Mukund Devgan 2017 is per incurium for not noticing certain provisions of the MV Act and MV rules. Prior to the enactment of the MV Act 1988, the legal framework governing motor vehicles was based on the Motor Vehicle Act 1939, which was incorporated from the English Road Traffic Act 1930. In January 1984, a working group was constituted to review all provisions of the Motor Vehicle Act 1939 and to propose necessary amendments. This culminated in the enactment of the MV Act 1988, which has since undergone several amendments. The statement of objects and reasons of the MV Act 1988 is extracted below for ready reference. Various committees like National Transport Policy Committee, National Police Commission, Road Safety Committee, Low Powered Two-Wheelers Committee, as also the Law Commission have gone into different aspects of road transport. They have recommended updating, simplification and rationalization of this law. Several members of parliament have also urged for comprehensive review of the Motor Vehicles Act 1939 to make it relevant to the modern day requirements. A working group was therefore constituted in January 1984 to review all the provisions of the Motor Vehicles Act 1939 and to submit draft proposals for a comprehensive legislation to replace the existing act. This working group took into account the suggestions and recommendations earlier made by various bodies and institutions like Central Institute of Road Transport CIRT, Automotive Research Association of India ARAI, and other transport organizations including the manufacturers and the general public. Besides obtaining comments of state governments on the recommendations of the working group, these were discussed in a specially convened meeting of transport ministers of all states and union territories. Some of the more important modifications so suggested related for taking care of the fast increasing number of both commercial vehicles and personal vehicles in the country, the need for encouraging adoption of higher technology in automotive sector, the greater flow of passenger and freight with the least impediments so that islands of isolation are not created leading to regional or local imbalances, concern for road safety standards and pollution control measures, standards for transportation of hazardous and explosive materials, simplification of procedure and policy liberalization for private sector operations in the road transport field, and need for effective ways of tracking down traffic offenders. As per the statement of objects and reasons, the important provisions addressed the following: rationalization of certain definitions with additions of certain new definitions of new types of vehicles, stricter procedures relating to grant of driving licenses and the period of validity thereof, laying down of standards for the components and parts of motor vehicles, standards for anti-pollution control devices, provision for issuing fitness certificates of vehicles also by the authorized testing stations, enabling provision for updating the system of registration marks, liberalized schemes for grant of stage carriage permits on non-nationalized routes, all India tourist permits and also national permits for goods carriages, administration of the Solatium scheme by the General Insurance Corporation, provision for enhanced compensation in cases of no fault liability and in hit and run motor accidents, provision for payment of compensation by the insurer to the extent of actual liability to the victims of motor accidents irrespective of the class of vehicles, maintenance of state registers for driving licenses and vehicle registration, constitution of road safety councils. The bill also seeks to provide for more deterrent punishment in the cases of certain offences. The above would suggest that the enactment of the MV Act 1988 was driven inter alia by the rapidly increasing number of vehicles in the country, the development of the road sector, and the need to promote the adoption of advanced technology in the automotive sector. It is also essential to note that the Law Commission in particular had made various recommendations concerning provisions of the MV Act 1939 and MV Act 1988 in its report numbers 85, 106, 119 and 149. To further understand the objective of the MV Act 1988, we may refer to the 149th report of the Law Commission titled Removing Certain Deficiencies in the Motor Vehicle Act 1988, which noted the challenges faced by victims and their families in seeking compensation under the MV Act 1988 and the rising frequency of road accidents in the following words: the frequency of accidents caused by motor vehicles and the pitiable plight of the victims of such accidents and dependents have been the subject matter of comment by the Supreme Court in a number of cases. Stop.